If you're going to have a trust, why do you also need a will? Hi, I'm Guy DiMartino. I'm a Northwest Indiana estate planning and probate lawyer, and today I'd like to answer this question for you because it was recently asked of me. And this was the scenario. Somebody came in for a second opinion regarding an estate plan, and they said they spoke to another lawyer, and the lawyer recommended a revocable living trust, and the lawyer also recommended a will. And they wanted to know if a will has to go through probate, and the lawyer recommended a trust to avoid probate. Why did the lawyer also recommend a will? And this is the type of will that we normally recommend when we do revocable living trusts, and that is a pour-over will. And it's sort of like having a belt and suspenders. What do I mean like that? So the goal is, if you have a trust, to have everything either go through beneficiary designation or to be titled in the trust. However, if you forget to have something titled in the trust, what you want is a pour-over will that says, hey, court, we want to take this thing, whether it's money, whether it's real property, no matter what it is, and we want to say, okay, it goes into the trust, and then it is managed by the terms of the trust. So a pour-over will says, hey, if we forget something that's not titled in the trust or go outside the trust by beneficiary designation, court, we want our assets to go into the trust and be managed by the terms of the trust. It's called a pour-over will. You take the stuff and you pour it over into the trust. So that is why the lawyer also recommended a will with a trust-based plan. If you have any questions, you can always reach out to me. I am Guy DiMartino. Have yourself a good day.